Hello, friends, and welcome back to another scholarly episode of the Liberty Weekly podcast. I'm your host, as always, Patrick McFarland, and this episode is episode number 96, and as always, the show notes may be found at libertyweekly.net/96. As I mentioned, this is a scholarly episode of the podcast, and as I've been starting my new job and trying to get used to that, and there's been a lot of challenges and a lot of getting used to, I was looking back at the Liberty Weekly podcast and all the episodes that I've done. I haven't really liked the way that the show has kind of progressed, the later episodes that I've been doing lately, so I wanted to switch things up a little bit. And searching back through the archives, I found that some of the episodes I'm most proud of recording, aside, from all the great guests that I've spoken to, and those are really great episodes, but my scripted episodes and well-researched episodes are the ones that I'm most proud of. And I think those ones are evergreen episodes that really stand the test of time that you can go back and listen to after years or months. So here's another one of those scholarly scripted episodes. We'll see how you like it. This one is about the Germanic Folklaw that existed in continental Europe before about 1100, 1200 AD. And I think it's very interesting. It reminds us a lot of the Anglo-Saxon law, and that's actually kind of a part of it too. So I've done work on that in the archives, and you can find those episodes in the show notes below. One of the big ones is the episode I did on the Magna Carta. So if you just search the Magna Carta on libertyweekly.net, or if you go to libertyweekly.net/36, that's my episode on non-state justice systems that'll come into play here too. But before we get started, as always, you know how to support the Liberty Weekly podcast, and that is at patreon.com/libertyweekly, where you can now sign up to become a supporting listener for just $1 per month. $1, folks. And in doing so, you can get a shout out on the show and a personal thank you email from myself. And if you so choose, you can also support the show at other tier levels. $3 a month gets you access to audio extras. $5 a month will get you access to video extras of the show. And there's a bunch of other bonuses that tack along with that. So check them all out at patreon.com/libertyweekly. Also, please don't forget about my Amazon affiliate link at libertyweekly.net/Amazon. Black Friday is coming up. That's a big thing. So just go to that link, and it'll take you right to the Amazon homepage where you can do your regular shopping, and I will get a small cut. All of your support, of course, goes to help cover my operating costs or to buying more books or equipment for the show. Really do appreciate that. I love all my supporting listeners. You really help this podcast run in the black ink so that it's not a detriment to me, and I can keep putting out content for you guys. All right, so the topic for this week's show stems from a great book that I've been reading entitled Law and Revolution, The Formation of the Western Legal Tradition, and it is quite a tome. It is by Harold J. Berman, and admittedly, I will be leaning on it as a crutch a whole bunch through this episode. So this copy of the book, you can't see it because there's no video component to this show. I thought it would be pretty boring and a lot of extra work, so there won't be a video component. But I did get my copy from the Mitchell Hamlin Law Library, which is my law school, my former law school, and they were giving it away, so I snatched it. And it's quite a tome, as I said. It's a great book, however. I'm really enjoying it. So while there is a proverbial boatload of great info packed within this book, I just wanted to focus in on the first chapter, which, as I said, covers the legal order of the Germanic Folklaw that existed throughout continental Europe prior to the 11th and 12th centuries AD. One of the biggest distinctions that the author of this book, Harold J. Berman, notes is that prior to the 11th and 12th centuries AD, there did not exist what we would nowadays identify as being, quote, a legal system. Berman defines legal system, the term, to mean, quote, a quote, distinct integrated body of law that is consciously systematized. So instead, what existed throughout Western Europe at this time was what Berman calls a, quote, legal order, which was, quote, largely undifferentiated from social custom and from religious and political institutions. He states that no one had attempted to organize the prevailing laws and legal institutions into a distinct structure. Very little of the law was in writing. There was no legal literature. law was not consciously systematized. It had not been, quote, disembedded from the whole social matrix of which it was a part. There was no independent, integrated, developing body of legal principles and procedures clearly differentiated from other processes of social organization and consciously articulated by a core of persons specifically trained for that task. And ladies and gentlemen, that core of persons would be myself and the legal class. And I know that some of the listeners that I have some disdain for that legal class, this highbrow assortment of people who are the only ones that are trained to and the only ones that are recognized that can interact with the law. But, that's what this podcast is for, is to break down that barrier. But in other words, this system of the Germanic Folklaw was very decentralized. And as I was doing the research for this episode, I was reminded again of the customary systems of law that I covered in episode 36 of the podcast, entitled, quote, Non-State Justice Systems, a Primer, at libertyweekly.net/36. So in that episode, I went through a few law review articles that chronicled the customary legal systems that exist either independently or semi-independently from the state all over the world, throughout rural and indigenous societies. This is a polycentric law, and I think it's really cool. So in that episode, there's a few links to a couple law review articles that I looked through. There's a lot of people that are dealing with this subject. However, there's a lot of work that needs to be done at the same time. Well, I just noted how the Germanic Folklaw system was very decentralized, and I have a few quibbles with that statement because I, of course, support decentralization 110%, but I would still like to posit that on some level, a legal system needs some amount of order and predictability and uniformity. And I think that market forces in a free market situation would create that, in the same way that every single rail line throughout the world is the same dimension, so that trains can go on everything, or that Wi-Fi devices work on every Wi-Fi signal around the entire world. I think that's the way it would develop. But I would posit and keep this in mind throughout the rest of the episode, that if the goal of some kind of social or legal order is to provide for efficient ways to solve conflicts over scarce resources, a legal order needs to be able to provide just and predictable ways to settle disputes. And in some ways, I think that these customary systems of law do not provide that per se. In episode 36, I detailed how in these indigenous societies, one feature of it is that you could go to all these different tribal courts, and each one would give you a different answer for how adultery was handled, for instance. And if each system, you could confront some problems there. So we're looking for uniformity, predictability over solving conflicts over scarce resources. So just keep that in mind. So to recap thus far, the Germanic Folklaw existed throughout Central and Western Europe, as I said a few times, prior to the 11th and 12th centuries AD. That is when it was altogether replaced by a centralized and ordered system of, quote, papal supremacy over the entire Western Church and of the independence of the Church from secular control. So more on that in a future episode, because we're just focusing on the tribal and Germanic folklaw that existed prior to that. But despite that complete 180 takeover of papal supremacy, this is when the legal order gets very ordered and institutionalized. But despite that 180, there's no understanding the main tenets of the Western tradition, the Western legal tradition, without understanding the Germanic folklaw. Both because the Western tradition emerged from the Germanic folklaw, it had its foundations in said folklaw, and it was also, paradoxically, a reaction against said folklaw. So you'll see what we mean just going forward. But now, to do a deep dive into the book, I'm literally just going to read passages from it and then comment on those passages, because there's just so much important information here, and it would take me a really long time to regurgitate it in my own type of paper. So here we go. So on page 52, Berman starts his section on the Germanic tribal law. So he says, the earliest known legal orders prevailing among the peoples of northern and western Europe were mainly tribal in character. Every tribe, or Stamm, had its own law. The Franks, the Alemans, the Frisians, the Visigoths, Ostrogoths, Burgundians, Lombards, East Saxons, Vandals, Suevi, and other peoples that were eventually combined in the Frankish Empire, embracing much of what later became Germany, France, and northern Italy. The Angles, West Saxons, Jutes, Celts, Britons, and other peoples of what later became England, the Danes, Norwegians, and other Norsemen of Scandinavia, and later of Normandy, Sicily, and elsewhere, and many others, from the Picts and Scots to Magyars and Slavs. So this really reminds me of Rome Total War. So every time we talk about these different tribes, it reminds me of Rome Total War, which is a really great video game where you can play all these tribes. But let's see, where was I? So in the period from the 6th to the 10th centuries, the legal orders of all these peoples, though largely independent of one another, were nevertheless remarkably similar. So I made kind of a, let's see, they were remarkably similar. I made a point to keep in mind throughout as we go through this episode that we are looking for a decentralized system, but on some level you want predictability in ways to settle conflicts. So maybe this is it. On the one hand, the basic legal unit within each tribe was the household, which was a community of comradeship and trust based partly on kinship and partly on oaths of mutual protection and service. So we have these interlocking systems of obligations instead of coercion. You could, theoretically, and I'm just postulating here, but theoretically it seems like you could pledge yourself to a certain community of comradeship and trust through oaths of mutual protection. So interlocking systems of obligation here instead of a coercive system. Violation of the peace of the household by an outsider would lead to retaliation in the form of a blood feud, or else to inter-household or inter-clan negotiations that were designed to forestall or compose a blood feud. On the other hand, there were territorial legal units consisting typically of households grouped in villages grouped in larger units often called hundreds and counties, and hundreds and counties grouped in very loosely organized duchies or kingdoms. In the local territorial communities, the chief instrument of government and law was the public assembly, the moot, or the thing, of household elders. Besides kinship and local territorial communities, there were also various kinds of lordship, feudal bonds, often formed by households commending themselves to great men for protection. So this seems like you have households, smaller units that would voluntarily pledge themselves to great men for protection. And this is a very warlike society in these times, too, very aggressive, as Bruce L. Benson's book, and I should integrate that book, but I've done work on that, too, within the Magna Carta episode. So these episodes pair well together. But at the head of the tribes and of the local and feudal communities stood royal and ecclesiastical authorities. In the course of time, the larger territorial and religious units represented by these higher authorities became more and more important. Kings continued to be called kings of a people, Rex Francorium, the king of the Franks, Rex Anglorium, and I'm butchering this, so I apologize, king of the Angles, until the 12th century. But similar terms were also used to refer to vaguely defined political territories such as Francia and Anglia. Also, the church, though ultimately subject to emperors and to kings within their respective domains, was recognized as a wider spiritual community which, though wholly without organizational unity, transcended all secular boundaries. So we have lots of different shifting units here, lots of different interlocking things and different levels of governance. So nevertheless, prior to the latter half of the 11th century, royal and ecclesiastical authorities did not attempt to alter in any fundamental way the essentially tribal and local and feudal character of the legal orders of Europe. This may seem less strange if it is understood that the economy of Europe at the time was also almost wholly local, consisting chiefly of agriculture and cattle raising, with subsidiary hunting. Population was sparse, and there were virtually no towns with more than a few thousand people. Commerce played only a small role, and communications were very rudimentary. What is strange from an economic or geopolitical point of view is not the weakness of central royal and ecclesiastical law, but the strength of central royalty and ecclesiastical authority. So it seems that this isn't an altogether anarcho-capitalist society. You still have royal and ecclesiastical figures that have some kind of authority, but the question remains whether that was a coercive authority or not. Berman continues, it was the central royal authority inspired by ecclesiastical councillors which was responsible for issuing the written collections, or codes as they later came to be called, of tribal and local laws that provide a great deal of what is known today about the folklaw of that period. So he goes on further, talks about the disintegration of the Western Roman Empire in the 5th century, and there was a fabric of Roman law that existed in the Germanic kingdoms, which diminished, and actually in many ways virtually disappeared. In other places, the memory still lived on in what was called a Roman vulgar law system, and this was mostly in northern Italy and Spain, also in southern France. It was a very simplified, popularized, and corrupted version of Roman law. It has been described, this vulgar law, as a law adverse to strict concepts and neither able nor inclined to live up to the standards of classical jurisprudence with respect to artistic elaboration or legal construction. And that's, Berman is quoting someone else there. So even the most advanced Romanist legal collections of the time, such as that of the 7th century Visigothic kings, consisted only of miscellaneous provisions grouped together broadly according to subject, but lacking both conceptual unity and the capacity for organic evolution. Perhaps the chief historical importance of these scattered survivals of Roman law is that they help preserve the idea that law should play a role in the ordering of political and social relationships. Also, the Church retained many remnants of Roman law as well as of biblical law, and consequently upon his conversion to Christianity, a Germanic tribal leader would often promulgate a set of laws consisting largely of the customs of his people. So we have the interacting here of the customary law along with the interaction of the church and the forces of the church. And as we noted earlier in the episode, it was when the church came in and really had papal dominance over the area that really pushed the evolution of the law, and there was some violent conflict and wars as well. And that's in many ways the thesis of this book, Harold Berman's book, is that generally in the Western legal tradition we have slow, very gradual changes that are punctuated with periods of revolution and violence that ultimately fundamentally change the system in different ways. And I would say, and the Collapsitarian in me would say, that it would be naive to think that this couldn't happen nowadays in America. So in some of the earliest of the surviving laws of the barbarians, as it were, was the law of the Salic Franks, the Lex Salica, I'm really bad at pronunciation here, was issued by the Merovingian king Clovis shortly after his conversion to Christianity in 496. It starts by listing monetary sanctions to be paid by a defendant to a plaintiff for failure to respond to the plaintiff's summons to appear in the local court. This seems like a way, a subpoena in a sense, trying to force or put sanctions on a party who won't respond to lawsuits or submit to the authority of the jurisdiction of the court. It also lists monetary sanctions to be paid by wrongdoers to injured parties for various kinds of offenses, including homicides, assaults, and thefts. These are typical provisions of primitive law. One of the principal purposes was to induce the parties to a dispute to submit to a decision of the court, the jurisdiction, as I just mentioned. That is what Harold Berman states. Submit to the local assembly, which would be the 100 court, instead of resolving their dispute by vendetta, or else to provide a basis of negotiations between the household of the victim and that of the offender. So again, we're seeing some of the hallmarks of an early society is the fact that instead of, pursuing violence or might equals right, the mark of civilization is that violence does not solve disputes, it does not make right. Moreover, violence is pure economic waste. They've realized the fact that in order to build any kind of great ordered society, they need a system of solving disputes without violence or bloodshed. However, not perfect. So sometimes they did not even have that effect. The injured party, in the words of one of the Anglo-Saxon laws, might either, quote, buy off the spear or bear it. The prevalence of private warfare was connected with the great difficulty of bringing a person accused of wrongdoing to trial or getting witnesses to testify or enforcing a judgment. So here we do see the great struggle to get people to submit to the jurisdiction of the courts. Some people would rather just, go the way of private warfare. Moreover, when I mentioned this problem when I mention anarcho-capitalism to people, the biggest people in the legal community, the biggest question that they have is how you would get people to submit to the judgment of the court without the coercive power of the court. It seems like a secular problem, right? We want to solve violence in the community. We don't want people to solve their disputes through violence. So then we have to use violence to get them to submit to our peaceful arbitration process. Seems circular to me. However, I digress. The earliest of the Anglo-Saxon legal compilations was the Laws of Ethelbert, and I'm probably mispronouncing that, promulgated about 600 AD. Ethelbert, ruler of Kent, had married a Christian and, according to tradition, had been converted to Christianity by Pope Gregory's emissary, the monk Augustine, in 597. Ethelbert's laws are remarkable for the extraordinarily detailed schedules of tariffs established for various injuries. I love this, man. So much for the loss of a leg, so much for an eye. This seems like liquidated damage provisions to me, where they just put, before the injury happens, they have a liquidated clause where they'll just say, okay, a leg is worth however many shillings, an eye is worth 10 shillings, so much if the victim was a slave, so much if he was a free man, so much if he was a priest. The 4 front teeth were worth 6 shillings each, the teeth next to them 4, the other teeth 1, thumbs, thumbnails, forefingers, middle fingers, ring fingers, little fingers, and their respective fingernails were all distinguished, and a separate price called a boat was set for each. Similar distinctions were made among ears whose hearing was destroyed, ears cut off, ears pierced, and ears lacerated. Among bones laid bare, bones damaged, bones broken, skulls broken, shoulders disabled, chins broken, collarbones broken, arms broken, thighs broken, and ribs broken. And among bruises outside the clothing, bruises under the clothing, and bruises which did not show black. Which is not a bruise, in my opinion. If the act of the defendant caused death, the price to be paid to the kin of the deceased was called wear or wehrgeld. Much of the written Germanic, including Frankish and Anglo-Saxon law, was concerned with settling different measures of wehrgeld for different classes of people. Somewhat more sophisticated than the laws of Ethelbert was the so-called Edict of the Lombard chieftain or king Rothari, written down in 643, 75 years after the Lombards had moved from what is now Hungary and Yugoslavia to what is now northern Italy. Of the 363 articles in the edict, almost 140 deal with penal measures. For the murder of a free man or free woman by a free person, compensation of 1,200 shillings was required, whereas the price for the death of a household servant was only 50 solidi, and for a slave 20 solidi. I'm probably mispronouncing it, solidi, and for a slave 20, a unit of currency. Murder of a free person by an unfree person was, quote, compensated by death. Various prices were stated for hitting someone on the head, cutting off someone's hair, cutting off someone's hair. That seems... hair must have played a very important customary role in society. Cutting off someone's hair, breaking various named parts of the skull, gouging out the eyes, cutting off a nose, breaking a nose, boxing an ear, breaking arms, with distinction made between simple and compound fractures. Very nice. Cutting off arms, fingers, toes. The little finger of a free man was worth 16 solidi, that of the half-free 4, and that of a slave only 2. So we've noted already how these different tribes had, it was decentralized, maybe not quite as predictable, but however, you're noticing a similarity between these two systems is that they have liquidated damages provisions for personal injury. And it's very interesting to me that it seems like a large part of this law is very concerned with intentional torts. No criminal, it doesn't seem like there's any no distinction between the criminal law and the civil law. Everything is private disputes between individuals. It's not like the 100 courts are going after these people of their own accord. You have parties coming to the 100 courts looking for relief. The institution of fixed monetary sanctions payable by the kin of the wrongdoer to the kin of the victim was a prominent feature of the law of all the peoples of Europe prior to the 12th century, and indeed of every Indo-European people at some stage in its development, including the people of India, Israel, Greece, and Rome. It is also an important part of the law of many contemporary primitive societies. So it's not very unique, I suppose, to the Western system, including the people of India, Israel, Greece, and Rome. It is, in many respects, a very sensible system. The threat of heavy financial burdens upon the wrongdoer and his kin is probably a more effective deterrent of crime than the threat of capital punishment or corporal mutilation, which succeeded pecuniary sanctions in Europe in the 12th and 13th centuries. So they're saying that the threat of taking money away was more effective than physical punishment, than capital punishment itself, and at least equally as effective as the modern sanctions of imprisonment, and it is surely less expensive for society. So we get a little argument here against the prison industrial complex. I don't know if Harold J. Berman is a libertarian or not. I don't think he is, necessarily. I'd have to know more. Although he does herald the Western legal system, so in some sense he must be quasi-libertarian, and at least equally as effective as the modern sanctions of imprisonment, and it is surely less expensive for society. Moreover, in terms of retributive justice, not only is the wrongdoer made to suffer, but in addition, in contrast to today's more, quote, civilized penology, okay, I'm getting a little spice from Harold Berman, in contrast to today's more civilized penology, civilized is in quotes, the victim is thereby made whole. So, Berman, Harold Berman, everyone. Yet the system cannot be satisfactorily explained on utilitarian grounds alone, at least insofar as the Germanic peoples of Europe are concerned. It was part of a whole ideology, a whole worldview, and that worldview helps to explain not only its sensible features, but also those which may not have been so sensible. For example, the marked differentiation of payments for the slaying of persons belonging to different classes, the enormous size of the payments in many cases, the liability of kindred for wrongdoing regardless of their fault, and the fixed tariffs for injuries regardless of the actual cost to the victim. So, yes, not very libertarian in that sense. You're getting different penalties, people placed not equally, but in different classes, families being liable for the acts of other family members. That's not very libertarian. Regardless of their fault, the fixed tariffs for injuries regardless of the actual cost to the victim, right? That's why in modern day, when you have a civil dispute, maybe a personal injury case, you have doctors come in and testify as to the bills of each party that each party incurred. So say you have a really complicated injury because someone hits you with their car. In this kind of system, they would say, okay, well, your hip is broke, your hip is out of whack, well, you get 50 shillings, right? Well, what if your medical bills cost 200 shillings? Well, that's too bad because we only pay 50 shillings for busted up hips. So there you go. In functional terms, the institution of monetary sanctions for crime payable by the kindred of the wrongdoer to the kindred of the victim is to be judged not primarily by the extent to which it served to deter or to punish or to compensate for crime, but primarily by the extent to which it served to forestall inter-family vendettas, and more particularly by the extent to which it facilitated negotiation and mediation between hostile families. So, in that sense, you're getting the main concern of this legal order was not to provide justice or to adequately compensate people, but to prevent open and private warfare. As we're seeing that, and I noted this earlier, was that the hallmark of a civilized society is not resorting to violence to solve your disputes. People, it seems at this point, have realized that warfare and violence is a pure economic loss, so maybe we shouldn't promote that in our society. Ideologically, however, both the institution of the blood feud and the institution of monetary compensation as a replacement of the blood feud are to be explained in Germanic societies by the high value placed upon honor as a means of winning glory, or Lof, praise, L-O-F, lof. In a world dominated by warring gods and by a hostile and arbitrary fate, weird, that's the term, W-Y-R-D, honor for a Germanic man meant, quote, getting even. Only by getting even could he conquer the forces of darkness that surrounded his life. The fixed schedules of payments provided a standard for evening those accounts. Loaf was gained when a person took what others defended, as it was lost when others took what he or she defended. Therefore, boat was, in its origins, essentially punitive and only secondarily compensatory. So it's not until you have this, the emergence of Christianity and the acceptance of Christianity, that the law is really concerned with morality or justice, it seems. Well, I guess you could say that the evening of accounts would be some form of justice. Therefore, boat was the retribution imposed by one household or kin group upon another. The challenge to loaf was particularly great in cases of homicide because the dead could never recover their own lost honor. The duty rested entirely with their kinsmen, whose first instinct was to resort to vengeance. Originally, the life or limb of the assailant himself or of another member of his household was demanded. In biblical terms, an eye for an eye, a tooth for a tooth. So that's why you get, in the Bible, you get this, if I'm remembering the Bible correct from my youth, an eye for an eye or a tooth for a tooth was frowned upon, correct? Right, honey? An eye for an eye or a tooth for a tooth in the Bible is frowned upon. You're supposed to turn the other cheek. Or if the offense had been caused by a non-human agent such as a beast or a tree, the offending agent itself might be required to be forfeited, so-called noxal surrender. The substitution of fixed rates of payment gave dignity to a settlement short of violence, while not altering the basic raison d'être, I hate French, of the remedy, which was the redemption of the honor of the household and the kin. Boat and ware were thus related to mund, which was the protection extended by the household to persons and groups associated with it, and to frith, which was the peace of the household. The king's mund and frith were like any other man's, only better. So you still have, not really anarcho-capitalist or libertarian, the king being supremacy over everyone else, however voluntarily pledged. So think of that as you will. The laws of Ethelbert, for example, provided that the king's mundbeard, that is, the penalty for violating the king's mund, should be 50 shillings, and commoner's mundbeard should be 6 shillings. Mund was violated, and boat or ware was to be paid when, for example, an outsider slept with the serving maid of the household, or slew someone on the premises of the household. Closely related to boat and ware and mund and frith were 3 other Germanic legal institutions: the surety, bor, the pledge, wed, and the hostage. Surety is B-O-R-H, pledge is W-E-D, and hostage is hostage. A kinsman might act as a surety for a man who agreed to pay ware but could not pay the full amount at once, or the debtor might give a valuable object in pledge, or he might send a hostage to live and work in the enemy household until the price was paid. All these legal devices reflected both the solidarity of the household and the substitution of tribute for vengeance in inter-household or inter-clan strife. In addition to the settlement of disputes by blood feud and by inter-household or inter-clan negotiations, the Germanic peoples from earliest times held public assemblies, moots, to hear and decide disputes. However, jurisdiction in most types of cases depended on the consent of the parties. Even if they consented to appear, they might not remain throughout, and even if they remained, the moot generally could not compel them to submit to its decision. Thus, the procedure of the moot had to assume and to help create a sufficient degree of trust between the parties to permit the system to operate, just as the procedure for inter-household or inter-clan negotiations, with its reliance upon sureties, pledges, and hostages, had to assume and to help create such a degree of trust. Yet it is clear that both the trial before the assembly and the negotiations between the households or clans were apt to be immensely hostile in character. Quote, he quotes, Berman quotes, the two sides faced each other with implacable hostility. determined to make no concessions and to forgive and forget nothing. The polar relationship between vengeance, blood feud, and pacification, composition of blood feud, in Germanic folklaw is an example of the intense dialectic of mistrust and trust which exists in many contemporary kinship societies. Claude Levi-Strauss has written that, quote, observers have often been struck by the impossibility for natives of conceiving a neutral relationship, or more exactly, no relationship. We have the feeling, which moreover is illusory, that the absence of definite kinship gives rise to such a state in our consciousness. But the supposition that this might be the case in primitive thought does not stand up to examination. Every family relationship defines a certain group of rights and duties, while the lack of family relationship defines enmity. Levi-Strauss quotes the following passage from Marcel Mauss. Quote, throughout a considerable period and in a large number of societies, men met in a curious frame of mind with exaggerated fear and an equally exaggerated generosity, which appears stupid in no one's eyes but our own. There is either complete trust or complete mistrust. One lays down one's arms, renounces magic, and gives everything away, from casual hospitality to one's daughter or one's property. In Germanic society, the trust-mistrust syndrome was closely related to the overriding belief in an arbitrary fate, and this belief in turn was reflected above all in the use of the ordeal as a principal method of legal proof. The two main types of ordeal were those of fire and water, the former for persons of higher rank, the latter for the common people. Yeah, very nice. Originally, though, these were invocations of the gods of fire and water, respectively. Those tried by fire were passed blindfolded or barefooted over hot glowing plowshares, or they carried burning irons in their hands, and if their burns healed properly, they were exonerated. The ordeal of water was performed either in cold water or in hot water. In cold water, the suspect was adjudged guilty if his body was borne up by the water contrary to the course of nature, showing that the water did not accept him. In hot water, he was adjudged innocent if after putting his bare arms and legs into scalding water he came out unhurt. A latter, more subtle ordeal used chiefly by the clergy was that of the morsel. An ounce of bread or cheese was eaten with the adjuration, close, O Lord, this man's stomach so that he cannot swallow this bread, cheese, if he was sworn unjustly. If he could not swallow or keep down the bread or cheese, he was guilty. Such primitive lie detectors may have worked quite well. In any event, there was a considerable resistance to the abolition of ordeals in the 13th century. The ordeal was a characteristic example, in Peter Brown's words, of, quote, the mingling of the sacred and the profane, a, quote, blurring of the border line between the objective and the subjective in human experience. It relied on a sacred and dramatic right to determine the judgment of God, yet it was, quote, mercifully slow and allowed room for maneuver of the evolution of the situation. The outcome was usually subject to interpretation by consensus of the community, thus small face-to-face groups, largely non-literate, could deal with problems of violence, deceit, or witchcraft in a manner consistent both with belief in the supernatural and with practical communal needs. So this is kind of a hallmark of my episode that I had with, that I alluded to earlier, episode 36, Non-State Justice Systems, a primer. It has to deal with customary law systems and the fact that they were very accessible to the common people. You didn't necessarily need a class of lawyers or judges or people to interpret the laws. There was a very high community interaction in these types of systems. So, and we're balancing that really with this idea of not really law and order, but predictability. The system of predictability whereby you can plan, and a system by which is uniform so you could go to different places geographically and expect quasi-similar results. And I think that, as we see with the Lex Mercatoria, as things really progress and human society becomes more globalized, not globalized in the bad way, but globalized in breaking down the barriers of communication and trade, I think that's where you get these forces of uniformity and predictability that emerge. The Lex Mercatoria was a system of private governance that emerged in medieval times, whereby all of commerce was facilitated. If you were a merchant, there were ways to handle things, a custom, a national custom or a continental custom throughout Europe itself. And this is exemplified in the Uniform Commercial Code, which is a piece of positive law that exists in the United States. But however, it does provide a uniform system by which merchants and commerce can be governed by. It does facilitate commerce in a certain sense. Okay, but I think we're coming up on time here. We're at about 34 minutes. I don't really want to go through the entire first chapter of this book. I hope that you've enjoyed the format of this episode. There is quite a bit left, but in the next episode, or if I pick up with this, the rest of the chapter concerns itself with how these trials would work, per se. How the trials would work, the nature of the legal systems. It has a lot to do with awesome oral language, and the way that, because the law wasn't really written down, but the way that people would pass language from, or the way that people would pass the law down, or how they would solemnize certain legal procedures, was to repeat oaths, and these oaths were largely poetic, rhythmical, they rhymed a lot, and I think that's where we get this special legal language, terms of art that maybe are used in our situation now, in our current legal system. I think it's really interesting. So we'll get into that in the next episode, but for now, I think we have this is on page 58 for my future reference. When I'm recording the next episode, we left off halfway through page 58. But in this episode, we kind of introduced ourselves to the nature of the Germanic Folklaw itself. We talked about a lot of liquidated damages provisions, some of the terms that were used, these interlocking relationships of suretyship, pledging, different families or households or hundreds pledging themselves voluntarily to different organizations, submitting to different kings, different modes of organization as well. So I hope you've enjoyed that. Please do check out patreon.com/Liberty Weekly if you've enjoyed this episode. I really do rely on my patrons to help my operating costs. Really do appreciate that. Otherwise, sign up for my email list at libertyweekly.net/email. Or please, if you have the time, give me a rating and review on iTunes, Stitcher, or Google Play, especially iTunes. That really helps spread my reach. Or if you've enjoyed this, please share it around with other libertarians or people who are liberty-minded. I really am trying to, as I said, break down this barrier between what we have now is the law being the sanctified thing that is not accessible to people. And that's kind of what I'm trying to do, is to break down those barriers, inform people of the law, inform people of where the law comes from, and hopefully spread some liberty in the process. So thanks everyone so much, and we'll come back at you next time with probably talking about that special legal language that we get into. All right, thanks everyone. Peace.
In the early days of the internet, radical libertarians were scattered, lonely, and faceless. Without direction, they resigned to scour the web, sifting through content providers in a wasteland plagued by YouTube demonetization, Facebook jail, and covert internet censorship. But then, in 2017, the Libertarian Union was formed. Finally, the average Joe libertarian could find a thriving community of independent podcasters and content providers, all in one convenient location. At Libertarian Union, we'll always have the latest news, interviews, discussions, and even movie reviews. With hundreds of episodes and more added all the time, you'll always find something fresh at libertarianunion.com.